My name is Nadia. I'm an attorney in our employment unit at Community Legal Services in Philadelphia. And I'm assuming, at least if your program is in Philadelphia, that you're already aware of our existence. We provide free legal aid to low-income Philadelphians. We also do policy work statewide on other issues. I'm here to talk today about the overtime rules, even though you've probably seen the news that those overtime rules were stayed in a court case that was filed in Texas. So we thought it was a worthwhile thing to present it to you folks anyway, because, speaking for myself, I think it's going to benefit a lot of low-income, middle-income people. People might have different opinions on how much your program can afford, etc., but that's what we're going to go through today. I actually, as I'm sitting here and thinking about all the things that you're being presented with today and all the things you guys cover, I connected with Betsy because we're doing outreach on paid sick days that are now available in Philadelphia, both to staff, right, but also to all of the parents. Any parent who has a child in childcare is a working parent or in school, and so you should just be aware in Philly there's paid sick days now. But as I'm sitting here, I'm thinking I should have brought information about. My office represents a lot of people who are on the Childline registry. You guys have to do Childline checks for everyone. A new decision just came out the other day, and that's just making me think about how there's really no more deadline anymore to appeal. So if you have someone that you wanted to hire at one point and you couldn't because they're on the registry, and frankly, some people deserve to be on it, but we represent people who did not ever deserve to be on it at all. A grandparent who was put on it because they fed a child eggs, not knowing that the child had an egg allergy, right? So people get put on the registry all the time because the Child Youth Agency is trying to cover their own butt and make sure that this person doesn't cause a problem in the future. That puts them on the registry and unable to work. So be aware that we represent people and we win those cases a lot, not all of them, but a lot of the time. And now there's just a decision that says there's no more deadline for appealing. That used to be just a 90-day deadline to appeal, and a lot of people don't understand why they need to appeal if they aren't in the field already, right? So I just wanted to put that out there. Contact us if you ever have any questions about that. Okay, back to the topic at hand. We don't really know what's going to happen with the overtime rules. They were supposed to go into effect today, nationwide. And what it would do is raise the salary amount so that anyone who's working over a certain amount would now, making less than a certain amount would have to be paid overtime. We created a very basic handout that is easy to understand for clients. We have not posted this on our website because the law changed, but this is just a really simple thing that'll explain to you the really basic stuff about this new overtime rule. So how does this work? There's all these terms of art in the law, so I just want to explain them to you and then talk to you specifically about teaching jobs and how those work under this professional exemption. So it used to be, and it still is as of today since the rule was stayed, that anyone making less than about $24,000 a year had to be paid overtime. So if you were making over $24,000 a year, there was the possibility that you didn't need to get paid overtime, especially if you met one of these particular exemptions for professional workers or high-level executive workers. So there's a couple different tests even today that you would have to make sure if you're running a program and you're the person setting the salaries. You should just understand that all of these exemptions are things that you need to be pretty sure of before you decide this person doesn't have to get paid overtime. The baseline rule, hourly workers have to be paid overtime. Most workers have to be paid overtime unless they meet a certain exemption, okay? So that's how the wage and hour laws work generally. So the rule that would have gone into effect today and may still go into effect depending how this court case works in Texas is that instead of anyone being paid less than $24,000 has to get paid overtime. Now it's going to go up to about $48,000, $47,000 plus a little extra there. So what does that mean generally? Just talking generally about salaried workers and not talking about your particular childcare and teaching kind of staff and the differences. Just talking generally about salaried workers, what that would mean is either employers have to give people raises to get them above that amount, so $48,000 would be a level at which you could be sure that you don't have to pay overtime. Therefore, you don't have to track hours, you don't have to be concerned about how many hours someone is working. That would be one option that people have. Another option would be to convert people to hourly at whatever level they are. Say they're making $30,000 or something like that. Figure out what the hourly salary should be and start tracking all hours and paying that person overtime for any hours over 40 in a week. Even if your payroll period is every 2 weeks, overtime is measured by every week. You probably all know this because you probably all have hourly employees too, but I'm speaking very basically here. Apologies for that. The third option would be to really put something in stone about absolutely not permitting people to work any overtime, so you don't have to think about week to week, are my payroll costs going to vary because people are working a lot of overtime this week or next month. Basically those are the options, either raising people's salaries to $48,000, apparently that's what Walmart's doing with starting managerial employees, and they've announced that they're doing it despite this court case being put in place. So not for every employee, but for supervisory people that aren't hourly. Probably everyone else on their staff is hourly, right? Other workplaces have had to figure out if everyone has been salaried and no one is hourly. If everyone's salaried, they haven't up to now maybe been really looking at how many hours is everyone actually working because they haven't had to think about it. But if you have salaried folks that are making less than $48,000, then you might have to think about tracking actual hours worked. In fact, probably something is coming down the pike, even if this court case slows it down. I mean, that's what experts think. Who knows? Congress is also talking about trying to challenge it and block it. So who knows how that'll turn out in the long run. But the bottom line is that for a workplace where everyone is salaried, has been salaried up till now, and there haven't been like payroll entry and exit and clocking in and out practices in place for the salaried folks, that's going to be something you're going to have to think about doing given this change. Either raising people above it or tracking it, right? And what I need to explain is that, as someone who represents people who've been underpaid, let's say we just had a big case against a home health care agency where people weren't being paid for all of their time and they weren't being paid for travel time from client to client, which is required. That home health agency is now out $600,000 because they were doing it wrong, right? You are responsible for all of the hours that someone's working. Even if you say no one's allowed to work 40 hours, if you know they're working more than 40, you're still responsible for that. So you either have to really be firm and about not permitting people to work more than 40 hours, or you're going to be on the hook for paying more than 40 hours if it's overtime. So a lot of times clients are doing lots of work at home, paperwork or other work, or making phone calls on off time. That is potentially compensable work. And if it brings someone over 40 hours in a week, be aware that that's the kind of thing you have to start thinking about if you haven't been thinking about that already. The thing I want to talk about, we have a flyer that's already been handed out, or not yet? Okay.
Yeah, I gave that one out.
Okay.
This flyer came from PACA. It says PACA special issue at the top. They put this out last May when the rule just was decided. And this one is specifically targeted to childcare. So I shared it with Nadia.
Yeah.
And
so we're going to talk about this one last, just because I wanted to raise with you folks a particular issue with daycare centers and preschools, because under the Fair Labor Standards Act, there is a professional exemption. Anyone who's in a learned profession, like a doctor, a lawyer, I don't get paid overtime, anyone who's teaching. Teachers are professionals, meaning they have specialized skills. That mostly it's something you went to school for, but it doesn't have to necessarily be that way. But anyone who's in a profession where they exercise independent judgment, potentially is exempt from overtime as a salaried person. And so elementary and high school teachers usually are fit into that category. When it comes to childcare or preschool, people's roles are a little bit different than just teaching and instructing all day. So there's a handout I wanted to give you from the Wage and Hour Division of the U.S. Department of Labor that just kind of explains at the very bottom about preschool teachers. You know, if you're teaching all day, if you have people on staff that are actually teaching all day, then they might fit under the professional exemption. If your teachers are taking care of kids' physical needs, feeding them, changing diapers, putting them down for naps, as well as teaching, then you probably won't get the exemption. The professional exemption has to be doing that work for most of their day. So they can be doing a little bit of non-teaching work, but it's around 20% or 25% of their day that can be spent doing non-teaching things. So you have to show that it's their primary duty to do the teaching work, and then you might be able to qualify for the professional exemption. I would recommend, if you think you have people like that on staff, to talk to an employment lawyer, a management side labor lawyer that can help you figure that out. Because again, you don't want to put someone into that exemption wrongly, and then you're going to be on the hook for that overtime money anyway. But be aware that in this world of education, there is that possibility for certain people in your workplaces to fit that professional exemption, and less so. It's harder to make that, I think, in childcare centers, maybe easier in pre-K. You know better than I do in terms of how people's roles are divided, but I wanted to just flag that for you as a possibility. Although, as someone who works in a workplace and is a union member of my workplace, if you ended up raising people's salaries to meet that exemption that were not non-teachers and keeping teachers at a lower level because they're exempt, that could cause some workplace issues. I'm just telling you that it is there, and it might be something that you already have in place in some of your schools, or you have your own experience with if you've ever worked as a teacher and were under that professional exemption yourself. So just be aware that things like training count as work time. If it's mandatory, there's only very few times when training programs don't have to be compensated under the law. These are the kinds of things that sometimes catch an employer unawares in terms of, looking at changing someone from just thinking about them as a salaried worker, and I don't have to think about their hours worked and their overtime hours worked. If they're now going to be changing this test so it goes from 24,000 to about 47.5 as the drop off. People in that category, you're now going to have to think more carefully about what they're actually doing during their workday. Are there certain things that they're doing that you could take off their plate if you're concerned that they're going to be working more than 40 hours a day, or just chalk it up to that's what's happening, and I'm going to have to, since I can't afford, maybe some of you can afford to raise them to 48,000 eventually, but if you can't afford to raise them to 48, then that's going to be what you're going to have to do, is track the hours and compensate them. But the tool sheet that Betsy has is going to sort of go over that in more detail in terms of playing through a couple scenarios. Does anyone have any questions about the professional exemption for teachers? Is that something that actually is in effect in anyone's workplaces? Mm-hmm.
So I guess I would just raise on behalf of the early childhood professionals
Mm-hmm.
in our group that I think it's different, this notion of teaching versus daycare.
Mm-hmm.
And I think we would all agree that for us, even the act of changing a diaper
Mm-hmm.
has teachable moments.
Mm-hmm.
And so the work that we do, even though it may seem custodial in terms of, the Department of Labor, I think we would all agree that it is a professionalized profession. And I just kind of want to point out that even the work we do with infants and toddlers, we would consider teaching, although it's not the same type of teaching as, children sitting down and doing worksheets or that kind of thing.
Mm-hmm. Point taken. I mean, I don't know how the courts would look at that kind of argument, they tend to look at things in a very black and white way. But the regulations about who is a professional employee and therefore exempt from overtime pre-exist this change, right? So it's already out there. I brought, pardon me, I'm a little sick.
Would you like some
I
water?
brought no, thank you. I have cough drops in the back. But I have a couple pages from the U.S. Department of Labor's Field Operation Handbook where they go over literally what's required to meet the professional exemption. I can point you to that. A simple Google search can lead you there if you wanted to take a look at it and figure out whether there are people on staff that might meet that professional exemption. So it is something to consider. I know that there's been some litigation around the country about who does and who doesn't, and that early ed has been identified as an area where it gets murky, right? So it's clearer for elementary and high school, but it's murkier for daycare. It's not impossible to meet that definition under daycare and early ed, but it's gonna be trickier. So you're really gonna have to think it through. So it's called the U.S. Department of Labor Field Operations Handbook, and when you Google that, you just go to the page about professional exemptions. I'm glad to leave this with you, and we can make more copies too if anyone wants to take a look at that in particular. So that may apply to some folks, but I think the general message we want to give is that there is a change either it's either going to happen this year or it's not. I mean, again, my understanding is that Republicans in Congress are going to try to block it legislatively, even if this court case doesn't end up blocking it permanently. Right now there's a temporary injunction as they figure out what's going to happen next. That's the Texas court case. Let's take a look at the handout that's called the PACA Special Issue Employers and Employees. So if you take a look at this, this kind of goes over more or less what I covered already with you folks. One thing I didn't mention that is if this rule goes forward, there had been about 12 years where that $24,000 level never went up. And so some people are sticker shocked at the fact that it's now up to $47,500 and never raised in between. So what is proposed in this new regulation is that going forward, every 3 years it'll go up a little bit more to keep pace with the economy. So that's something to be aware of if the rule goes into effect, that it's $47,500 right now, but it's gonna go a little bit higher every 3 years or so. Again, it doesn't apply to hourly workers, but it does, and this is maybe an easier way to explain it than I did in paragraph 2, that it does not apply to salaried workers who do not meet the white collar overtime exemption. So I was talking about executive, administrative, or professional. Professional is the one for teachers and doctors and lawyers. Executive or high-level folks that are making over $100,000 and doing certain executive things. Administrative is not someone doing clerical work; it's someone having a way to exercise independent judgment. So that's another thing you might want to look into for certain people in your organization. But anyone else who's salaried, and probably most staff of yours that are salaried and not hourly, this would apply to them. And so I think that that at the bottom here, there's a couple of ideas in terms of what we want to talk about next.
These questions are what we're going to talk about when we break into small groups.
Mm-hmm.
Looking on the back, it's really some interesting information where it tells you about some examples of what a director's salary might be, an assistant director, and a curriculum specialist, and how that would play out as far as raising their salaries or limiting their hours or switching them to hourly. So this part might be really helpful for you to look at when you get back to your programs and you're thinking about how you're going to implement this.
Mm-hmm. So do folks have any questions, or are we ready to break up into the small groups?
Yes, I think. Any questions before we break up? Okay, now as you can see, there are 5 questions at the bottom. So we're going to break you into groups of about 5 or 6. You can just stay where you are and turn so that you can talk to the 5 or 6